Recently, California adopted legislation that grants rights to registered domestic partners similar to that of married couples. Since this law is still new and changing, numerous questions as to its application remain unknown. Nevertheless, there are many parts of the law that are reasonably clear. For instance, whenever the word spouse is used in the California Family Code, registered domestic partner is now synonymous. That means that California's community property laws apply to registered domestic partners. In addition, since 2007, registered domestic partners were also required to file California tax returns as a married couple. And in May of 2010, the IRS confirmed this interpretation of tax law by additionally requiring that registered domestic partners split income on their federal income tax returns. Besides the family law and income tax consequences of registered domestic partnership, however, there are also probate and estate planning implications for each partner. Generally speaking, where registered domestic partners memorialize their estate planning wishes in a will or a trust, the will or trust will govern how their assets are distributed upon death. Similarly, instruments that pass outside of the probate process, like joint tenancy and beneficiary designation, will govern the distribution of the assets subject to those designations. Where registered domestic partners fail to complete estate planning, though, the rules of intestate succession apply. And here again, wherever spouse is mentioned in the probate code, registered domestic partners now also have similar rights of inheritance. That means that if a registered domestic partner passes away with an estate plan that fails to mention the other partner, the omitted domestic partner will have a right to an intestate share of their partner's estate. Also, a registered domestic partner now has the same rights as a spouse does under the probate code to participate in a conservatorship or probate. Plus, a registered domestic partner can avoid a probate with a spousal property petition where the domestic partner left all of his or her assets to the other partner in a will. The list goes on and on, really. The point to take away, however, is that many rights under the family and probate codes were gained with the passage of this new law. Still, because registered domestic partners have not been recognized as married couples for federal transfer tax purposes, several important tax benefits have not been conferred on registered domestic partners. It's also important to point out that since registered domestic partnership is not recognized in other states that don't recognize same-sex marriages, all of the previously mentioned rules may not apply there. That means it's extremely critical for same-sex couples to complete their estate planning, especially upon a move to another state. If you would like to discuss the planning opportunities available to you and your partner further, please schedule a free appointment here at the Trust Store.